is you can put in the questions in the chat box. And then, like I'll try and answer them on the way or just later on at the end. All right. So let's jump into it. So what does open source essentially mean? That's my introduction, which Mukta has already given, so that's okay. So what does open source actually mean? Some people use the term open source, but the common term more prevalently used, which is more of a genus category, which covers free and open source licenses. So free software is another animal and open source is another animal, but they are closely related from the two species of the same genus, I mean, as such. So a lot of people call these as FOSS licenses. So let's see what I mean conceptually, what is this about? What's open source licensing about? And what kinds of licenses exist? And there are many of them. And essentially, what are the basic risks around using open source software if you're doing, like a venture and you're essentially either doing a SaaS product in the sense like you're providing a software as a service, or you're selling like shrink wrap software to somebody and you use, like open source components to it. So those will be the challenges to consider. Okay, so let's see what it is as a concept. So there are two viewpoints to this. One is the programmer's viewpoint of people who code, and there is a viewpoint of, like the lawyers or the business people, as to from a copyright point of view, that what's the challenge regarding the open source. See, in normal course, if you as a programmer are developing something as a software, if you are doing it for yourself, then you are the owner of it, because copyright doesn't exist in ideas, but it attaches itself to any idea which is expressed or stored in a tangible medium. What could that be? Paper, pen, paper, electronic documents, stone, whatever it may be. So copyright attaches automatically to any expression of ideas which is stored in a tangible medium. So it's known as a sui generis right, in the sense you don't have to register it. It automatically attaches itself to anything that is like expression of, like human expression of something that's stored in a tangible medium. And that's why there is a lot of debate you would see, with DALL-E and ChatGPT and other applications which are generating content, that who's the author here? Because the current interpretation of at least the Library of Congress, which administers the copyright in the United States and around the world, is that you need a human author. You cannot have artificial intelligence or machine software, essentially being called author of something. But the reality is that if you look at ChatGPT, although Google's Bard is not available in India, but if you look at ChatGPT, it can generate a lot of code too. So what's there to, like essentially not allow, like copyrights to that particular code. You also, like in regular coding tools, the IDEs, as they are called, integrated development environments, there is a lot of, aid to writing code. So Microsoft calls it IntelliSense, whereby you can complete, like you just type something, then it automatically sort of guesses what you want to do and fills up like some of the parts of the course. That's just like, in Google, if you type a search, it already knows what you are looking for, and it gives you a suggestion that maybe you're looking for this term or that term. That's kind of a look ahead or suggest ahead kind of system. So that exists for coding also. And so we already have, like what would be like cruise control in the car that exists for coding. And there people don't have much of problem because the human seems to be in charge, and he's the one who is like, he or she is the one who is writing the code. So that's like okay, and copyright can be granted to it. But purely generative AI, where code is completely being generated based on prompts or some small inputs given, copyright offices are not comfortable with granting, like recognition to software as author. What will happen eventually, we don't know, but uh, some compromise has to be worked out, because AI is going to generate a lot of code. It's going to generate a lot of chemical equations. It's going to generate a lot of imagery, whatnot stuff. I mean, so and that's how it is going to be. I mean, so we'll have to live with this, like humongous amount of content in everything: scientific, technical, programming, literature, whatever AI generates. I mean, we'll have to find out a way to deal with it. So in terms of like copyright getting attached to code, if you are a sole programmer and you're writing, say, C++ or C# code, copyright automatically attaches to your code. Registration gives you some additional benefits in terms of determining a date. I mean that anything which is registered obviously was created before the date of registration. So that gives you a certain presumption of date of creation of that particular copyrighted material. That's like the idea of a copyright, I mean. And copyright essentially works on this mechanism that it has certain categories to which copyright is given. Not everything expressed by human beings is copyrightable. You have, like literary works, musical works, you have sound recordings, you have cinematographs and all that. These are common categories to which copyright attaches. It does not attach to pretty much everything which is out there. So from coding point of view, code is copyrighted. Code can be copyrighted. Code can also be patented, but that's not the most correct statement to make, because you're not really, like patenting the code. What you're doing is essentially patenting, like an innovative idea which is technical enough, has utility, and has inventive step, which means it's non-obvious and you're getting a patent on that. So that's that. So the patenting part, so the software has gone through a lot of back and forth that whether it can be patented or not. Most jurisdictions now say that it's okay, it can be patented. I mean, at least the core technical concepts underlying code can be patented. But there was never a debate that whether code can be copyrighted or not. Code has always been copyrightable. And this generated a challenge whether, to allow, like a complete copyright regime which exists, for example, in music and which exists in literary work, that nothing can be copied or created without, like copyright permissions or licensing being done. So the coding world has a different DNA as compared to the traditional literary works or musical works, because it's not that hard. I mean, musical works are hard to create, and their creators may obviously expect a lot of royalties for what they have created, because a tune which is created once and which will be recorded will be played millions and millions of times over and over again if it gets popular. But code also, one can argue that it could be used millions and millions of times again once it's created. But there is a lot of people in the software world who felt early in the 80s, like after Unix came on picture, that came in 70s, but 80s onwards, there has been thinking that I want to create software, but I want to give it away for free. I don't want any money for it. I want to collaborate with a lot of people, and we want to collaboratively build large software models, and we don't want to charge for it. Sounds extremely un-American, but that's where the free software movement started, FSF started. At MIT, Richard Stallman, is the pioneer. And he created, recreated sort of, what are Unix utilities. And Linux came in with a kernel I mean, and they used, FSFs as all the ready utilities and recreated, a very popular Unix model, recreated the Unix model. This was already done by somebody else called Mr. Bill Joy, who later on co-founded Sun. He created what is known as BSD. So that stands for Berkeley Systems Distribution. So BSD also was a Unix clone, and it was single-handedly written by Bill Joy. I mean, here, like Stallman wrote lots of utilities, but there were many others who contributed to free software, and Linux kernel itself, although Linux Torvalds is the main keeper of, Linux kernel, but it's essentially, like hundreds and hundreds of contributors who contribute to Linux kernel as such. FSF has tried to create kernel, as most people from the coding world would know. It's known as Mach, but it's not nowhere near completion. Mach and Herd, I mean. So, oh, okay, it's Herd actually. Mach is is BSD's kernel, I mean. Anyway, but BSD's kernel actually, because it is free software, it is used as the underlying Unix for all Apple desktop softwares. I mean, I don't know the phone uses a BSD version or not, but which is the iPhone. But all their Macintoshes and the laptops, I mean, they do use, the version of this essentially BSD underlying, which is the BSD. They have called their kernel as Darwin, but it's pretty much the same. It's the BSD kernel, and they are the ones right now maintaining most of the BSD kernel. But yes, so a lot of software was supposed to be created free, and it was meant to be like shared with everybody and all that. So free code culture came up, and we needed a new system because who created parts of it was completely unknown sometimes, and who were the contributors, God knows, because they all worked anonymously through lots of internet chat boards and internet relay chats and IRCs and whatnot. So authorship became very secondary. So what happened is this new kind of thing came into the picture, which everybody said that we don't want the ownership of it. What we want to control is distribution. So most of the free software actually is copyrighted, but they give you a license through which you can freely copy, remix, redistribute it, even for a small fee. Some of it allows you to make commercial use of it. I mean, but with a one particular restriction. That restriction is known as copy left. So it's a pun essentially on copyright, that in copyright you tend to like control. Here you actually give away stuff, but with the condition that if you modify it, then you will also have to give the modification away to the world for free. So a lot of people call it a viral license, in the sense that it propagates like a virus, that it makes copies of itself. The FSF license, which is known as GNU. GNU actually stands for, it's a recursion. GNU stands for GNU is not Unix, I mean. So GNU has a license called GPL, which is GNU public license, which is a viral kind of license, in the sense that any modification made to GNU's free software, it will have to be published, made available to the world, and you will not be able to claim rights in it, I mean. So that's FSF's, GNU, GPL, FSF's model of copyleft software, that yes, you can use it for free, no problems, use it for commercial use or your personal use. But if you modify it, then you will have to, give away your modifications for free. So that's the idea behind it. So it's free to use and to copy to, no restrictions. The code can also be shared freely, but same copyright notices have to be carried over. Across all the licenses, there is a generic requirement that the same copyright notice through which you received free software will have to be carried over to other distributions and make it available to other people. Libraries can be called, even proprietary libraries can be called through this software, and free software can be included along with commercial software or closed source software as it's known, as in contrast to open source software. And closed source software can make library calls or call functions from open source software, and whole thing can be packaged together. Now, free software folks at GNU are not really comfortable with this arrangement, but they have to accept reality of the world. So they created LGPL as a license, lesser GPL, and we'll see what different kinds of like those licenses are. And all of them essentially differ as to the restrictions they put. One on commercial use, and secondly on, like whether the modifications need to be redistributed or not. So those things have to be like considered. So from a copyright point of view, like code is, this is, earlier we saw what's the programmer's point of view. Programmer's point of view is that, okay, I need not reinvent the wheel. Let me take up, like ready-made software, for example, to edit PDFs or, like read some Word files or everything. Yeah, this has been done by tens of people earlier. And let me pick up the best open source module for it. And let me just call it, to like either do a printout on a particular printer or send a file across the network or something which, like routinely done over and over again, and which for it already there is free software available. So that's programmer's point of view. But from copyright point of view, which is lawyers or business people's point of view, code is copyrighted, but it comes with a copyright license, which is irrevocable, non-exclusive, worldwide kind of a license, which means everybody is free to do, but it comes with its own conditions. So those conditions, and one of the prime conditions, as I said, is that the same license would be copied over and given in future distribution. So it travels like a virus, a DNA of a virus, along with all the free software. Permissions are there to copy, remix, reuse, and redesign the code. There are varying conditions across OS license, and that makes, this seminar possible, that what are different kinds of OS licenses and what needs to be done with it. Copy-free redistribution is possible. Cost-free redistribution is possible, so you can freely redistribute. In the times of floppy disk and tapes, there was some small charge, given for, you were allowed, you could take a small charge, and some modern licenses allow people who are redistributing it to charge for not only just copy and distribution, but also for providing warranties. Because another common feature of all the software is that everything is provided on an as-is basis. There are no warranties, that you are using free software at your own risk. If your server crashes or something gets deleted, you can't sue, like the authors for any kind of warranties, as such. So the key concept here is copyleft, which I've discussed, that it's the virality of the license itself. So this is, like the key text from the Free Software Foundation's GNU license 3.0. It's gone over and over to certain things, certain improvements. The 3.0 is what you would find this thing, and this is the license under which Linux kernel is also released. That's the GNU license. So although the GNU guys say Linux is not really free and all that, but that's what it is, as such. So the main thing in this license essentially is, first, there are two categories. One, like you're allowing verbatim copies to be made, means as it is copies to be made. The text on the slide is actually from that license. So you can convey verbatim copies of the program source code as you have received it through any medium, and publish on each copy an appropriate copyright notices, keeping all previous notices intact. So there is a lot of there will be cascading notices, as you make modifications and all that. But you all that notices cannot restrict people's right essentially to copy and modify the code. I mean, so that's why a lot of people say that open source comes with a license to remix. I mean, so remix code, I mean, as such. So you can charge price or no price for each copy, and you can convey, you may offer support or warranty for a fee. That's fine with them. That's not a problem, because that's services which are provided over and above this software, I mean. So they are okay with that. So then the other challenge is what happens when you want to release modified source code versions under GNU licenses. This is where the virality of this particular license comes into picture, that you must license the entire work as whole under this license to anyone who comes into the possession of a copy. So it essentially means that whatever modification you have made, you have to license the whole modified version, including what came to you, what you have used as free software, and whatever modifications you have made it. And this will be licensed on the same terms of copyleft. I mean, where next person who is using it, again they modify it, again it will be retransmitted with that modification. It's okay if there are hundreds or thousands of like modified versions of the same thing, which if you have used Linux, you would know that there are tens or rather hundreds of distros, as they call it, distributions. And each, like Ubuntu is there, you have Red Hat use Linux, you have Oracle Linux, whatnot. I mean, free softwares exist, Linux versions, and all of them, IBM has one. All of them essentially are under this license, whereby whatever modifications they have made to that software, SUSE or Red Hat or whatever company which has made it, they have to, Red Hat now is bought by IBM, but they have to make it available to rest of the world. So no keeping back the changes with yourself if it is licensed under GNU 3.0. So that's the main difference. So what is, this is there on GNU's website. There are 4 characteristics of these particular free licenses, I mean, or GPL licenses. You have freedom to use software for any purpose, which you can use, like any like free software for commercial purpose also. They have no problems. You have freedom to change the software to suit your needs, so you can adapt it for your needs. You have freedom to share the software with your friends, neighbors, etc. So that's distribution. You have a right to distribute it, but you also have the freedom to share the changes you make. Rather, you don't have just the freedom, but you have an obligation to share the changes you make to this software. So that summarizes sort of in one slide, like what this free software movement is about. And it's actually done quite a good. I mean, like today, like half of the computing, it may not be an overreach to say half of the server-based computing runs on Linux. I mean, instead of proprietary software based on which the mainframes and like servers from digital research and IBM and etc. used to run. It's all run on essentially like Linux and free software. So there is nothing to say that this has not worked. It's been a commercial success minus the commerce. There's no commerce behind it, but it's a great success. I mean, just due to the virality of it. I mean, interestingly, you would think that maybe somebody may guess that there might be a lot of litigation around free software. There has been very minimal litigation around free software. Very few cases have been there around GPL license. So that's another reason why it has survived, all kinds of legal scrutiny or changes. It's been just changed, updated 3 times. It's for the simple reason that whoever uses free software uses it with complete responsibility when they make changes to the code and, like use it for even for their own purpose. They will have to, like release the changed code out for others to use and remix also. So this is a diagram from, like the GPL website, the FSF GPL GNU website. So they say that GPL version 2 and version 3 are the strong copyleft licenses, which means you can use it for whatever purpose, but if you make changes, then all those changes will have to be released to the world. Then they say this LGPL, which are kind of library licenses, whereby free software components and non-free software components will live together. Then essentially, I mean, uh, you will have, both of them can coexist in one package, but you cannot modify LGPL code also. So if you, by chance, if you modify any of the code, you can package it together, link it together. Those from computer science background would know that, if you have source code, you run it through a compiler, it creates object code, and then you have a linker, which links it to the existing libraries to which function calls have been made, and then creates an executable. Now, for this purpose, you can, LGPL license allows you to, include the copyrightable and non-copyrightable, the free and non-free components, but they say it's a weak copyleft, because if you make any changes, then it becomes almost a GPU license, the same as GPL license, which will force you to release the changes into the world. But if you are going to use a free software component to link it to any or bind it in a library to other components, but if it is used as it is, then you are fine. Then you don't need to do any changes, release it under like source code underlying it. But you will have to, essentially release it if you have made any modifications to its object code, which is coming to you. And then there are these permissive licenses. These are all these different permissive licenses. So Apache is there, X386 is there. You have X11 licenses, that's an X Windows license, expat, ISC, whatnot. But the strongest is public domain. Public domain essentially means you have released something in the public domain and you simply don't care, what anybody does with your code as such. And then you have a modified BSD license and zlib licenses. Each comes with a small flavor and quirk. But as you would understand from the later slides, that the variations are not really much different. So this is the lesser GPL. As I said, like copyleft applies if GPL components are modified. Then there are types of FOSS licenses. There is a list here at opensource.org licenses. Comparison is available here between different kinds of like free software licenses. The totally free license is public domain. Once you release it, the ownership is gone from you. And it's just in the public domain for anybody to use it in any way and do anything they like with it. The main concerns regarding free software are whether you can do commercial use of that software or not. And secondly, whether there is a requirement to republish, which is the copyleft and permissive requirements, and attribution. So attribution is not hard. You take up, like any commercial software today, and they have a lot of attributed components. You can go to Adobe Reader or Adobe Acrobat and just check about, and you would see lots and lots of, free software components are used there. Also in many things, now free software has entered, but commercial software vendors, like whether it's Oracle or it's Microsoft, they have to be very careful in how they do mix and match of these open source components along with the other drivers or like supporting software they have built into their core products, whether it's databases for Oracle or it is word processor and Office software for Microsoft. So this is, we'll go back a little. There are all these too many types of licenses, but one of the permissive licenses is known as an MIT license. So MIT license, apart from the general requirement, two things that you will include copyright notices which were present in the software that you had received, and also that this is being given as is and without any warranties or guarantees of any kind. Apart from that, they have a very simple permission license that permission is granted hereby free of charge to any person obtaining a copy of the software and associated documentation files to deal in the software without restriction, including without limitation, the rights to use, copy, modify, merge, publish, distribute, sublicense, and or sell copies of software, and to permit persons to whom software is furnished to do so subject to following conditions. That following conditions are essentially it's on as-is basis, and that you have to include, like this copyright. But the main thing here is that you can use this software for commercial purpose. That's not a problem with MIT license. So MIT is one of the flexible permissive licenses that's available, and a lot of MIT software. So if you have used, there is a kid software called MIT Scratch, and a lot of people have done amazing things using Scratch. That's all released under the MIT license as such. So there are restrictive licenses. One of the examples is Apple's public source license. So Apple also has a public source license. But question is, like it has a lot of conditionalities. One is whether you are actually releasing the code verbatim, or are you modifying it, and are you using it only within your organization, or are you making it available to those outside your organizations? And excuse me, and there are different levels of conditions that Apple has put in, but that's an example of a restrictive license. A lot of commercial use licenses exist, as MIT one I showed. So this is the BSD license. And the source code must retain the above copyright notice. That's the notice requirement, and also there will be a warranty disclaimer that we would not be liable if anything goes wrong. Those two are fine. Nobody fights about those. Redistributions in binary forms must reproduce the above copyright notice, which means whether it's in the source code form or binary form, the notice has to be included. Neither the name of the copyright holder nor the name of its contributor may be used to endorse a product or promote products. I mean, I'm sure, like nobody's keen to do that, but that's about it. Otherwise, BSD is fine with, you using their software to create commercial software. And they also, both MIT and BSD licenses, if you would have seen, they don't have a requirement that any modification made to that software will have to be released to the larger world. Then there is an Apache license, very similar permissive license. Its focus is on redistribution, because this is the most popular middleware web server license, that web server software that exists, Apache servers. And they are like common across many things. Apache makes many other things, but it's essentially the web servers, I mean, for which it is the most famous, most well-known as the most famous software. So you can reproduce and distribute copies of work or derivative works, thereof in any medium, with or without modifications in source or object form, but with these conditions. It has an interesting condition that you must retain in the source form of any derivative works that you distribute all copyright, patent, trademark, and attribution notices from the source form of the work. So you need to retain all the past notices which have come. So that's the notice function of it, and include a text file which they have supplied, which is simply a copyright notice, I mean, which you have to include with anything that you are copying or sharing or redistributing. That's about it. Otherwise, like Apache also allows you to create, your main, the work as it was received by you, or even a derivative copy of it, or undertake commercial use of there is no end use restriction. Anybody can make commercial use of the software without paying anything to the copyright holder for the code. There are lots of risks associated with the OS licenses, and those are principally around when you use them in commercial ventures. So to tell you, I had a client who has developed, some machine learning software, and there were investors wanting to put in money into their this thing. So they wanted a very clear opinion whether they can, how much of the software is open sourced and what is closed source, and how will closed source be protectable from open source, because open source has this amazing requirement that if you have modified it, you will have to release the modification out there in the world. And along with, any software which is packaged with it, the same rules would apply with it. So very dangerous in that sense, in terms of rights. But that's, way the open source system works, I mean. So what are the risks? I mean, so any investor will want clarity on asset rights, that if they are investing in your company and companies, all the software is open source, then, like what are they investing in? People essentially paying people salaries, and people can walk away anytime. And there's no code or asset, I mean, in terms of the software which the company may have, because open source means everything needs to be released. So if code is, like GPL or modified LGPL components, it will be easy for others to copy or even demand a copy from you. They can demand a copy if it is lefted software, that please give us a copy of it. It's easy to copy code, and like all the changes can be made easily. If somebody has source code, let's say today Windows is closed source, but if Windows were part open source and part this thing, and you could get a copy of Windows, why not? Like you would like to take the copies of Windows, hack it, and create a new version of it. And that's what's happened to Linux. Anybody and everybody comes and creates a fork, like from where you can download Linux source code and create your own branch or own version of Linux source code, and then give it back, like make it available to rest of the programming community. So that's how like this works. The investors, like picky investors, would like a clean room approach, in the sense that you don't use any copyrighted, I mean, open source software, because they simply don't want to run the risk that ultimately they get into a litigation, or they, like essentially lose money because you didn't have a copyright and somebody else just copied, whatever was your work. There is competitor risk, because you cannot sue a competitor if they have modified your GPL code, because GPL allows you to modify. All that it requires is that the notice has to be carried over to the modified version. So somebody can take that code, modify it, and create an improved version and release it later. That would be satisfying, what the free software's mission was, that people receive code, fix it, I mean, change it in some better way, and then release a new version into the free world, into the free market as such, literally free market, because it's free. You can't charge anything for it. In practice, it's low risk, I mean, because the software is a black box. It's very hard for people to figure out that where is the software innovation, in the sense whether a particular piece of software is used in open source or not, because what's distributed, what's running on systems are essentially, like in the form of object code or binary code, without source code being into picture. So it's very hard for anybody, even the owner, to detect whether of that person who created that free software, to detect whether it's being used or not used, because it's just the way the black box nature of the software is. So hard, I mean, to detect it. So if it's very hard to detect, why pursue it? But if you have a unique piece of code, then it's worth pursuing it and getting the necessary protection in India, US, and other markets, whatever you may be targeting. That's about it. That's me. You would find all that stuff on the PDF that's been circulated to you. And that's it. I mean, these are my small set of slides and my ideas and thoughts about it. What I'll do is I'll take questions. I'm stopping the sharing for it, but there were some questions in the chat box.
Hasit,
yes, yes,
Dr.
Me,
but while other people are putting in their questions, maybe I'll give it a shot.
Yes.
So on the GNU license, for example, if you have a layer on top of it, which is proprietary, is that possible? In the sense,
it's possible, but if your software interacts and calls that code essentially, so that itself is considered, like use of that code. So as soon as you access, like the GPL code with your proprietary code, you're automatically, it will have to be released. I mean, because it would be considered a modification.
Okay. So somebody also has asked the question, is there a open source concept for music also?
Yeah, so what I have not touched here, and because we were, focused on open source software, and open source is used in context of software, there is a whole set of licenses which are known as Creative Commons licenses. So you can go to cc.org, that's their website if I'm not wrong. It was started by a professor who now has moved on to some other interests. But otherwise, to the political corruption and those kind of like academic research topics. But this like Creative Commons software dealt with the copyright challenge. For creators who wanted to give it away for free, and they wanted, like others to copy it, remix it, create newer versions from it and all that. So those Creative Commons licenses are there. So Dr. Premnath has put up the the URL for it, which is creativecommons.org, and you will find a variety of licenses there. So CC-0 is essentially means public domain, that there are no restrictions. As such, you can release anybody can do anything with it and not even give attribution. Then there is a license whereby you can make commercial use of the like whatever has been distributed, and you can also remix, like this thing, but you will have to give attribution, which is very common in scientific world, that you have to attribute, like the source from which you got the idea, or somebody else's work is incorporated into your work. But there are extremely restrictive licenses also, which don't allow you commercial work, commercial use of that work. They also don't allow you to make copies of it and all that. There is a range of restrictions you can do, but they say that these are not the free licenses. Where, like you cannot, as soon as you say that somebody cannot remix your work, you are outside the free culture zone. And they have their own search engine. Google also allows you to search for Creative Commons licenses, Google and other search engines. So this is quite a big category. If you go on Flickr, there are thousands and thousands of accounts which have like software license under Creative Commons. You go to Metropolitan Museum of Art and many other museums of art, they have released most of their photographs and their catalog, not the actual work, but their catalog, which includes photographs of like historic works and all that, under a Creative Commons license. You'll have to give, for certain things attribution, for other things nothing. It's just released into public domain. So I've not touched the copyright part and the music part of it, because it's a huge world by itself, and it's even more dangerous. But this kind of virality, which, like the GNU, FSF GNU license has, GPL license has, that is not, like seen too much of a problem or challenge in the Creative Commons world, because remixing is very common in art, literature, and music world. So they are okay with it.
Hasit, there's a
Yes.
Pankaj wanted to ask a question, so I've unmuted him. Yeah, go ahead.
Sure.
Yeah. So, sir, my question is related to this question only, that like when in the software we are doing this open software, so like you have done modification, it remains copy left. You can't, like have a copyright over that modification.
Yes.
Now, bringing the same thing in the music industry, I'll share with one example that like in music, rappers like Basha, and they do certain modification in the known folklore in Haryana and all those places, and
Correct.
then they start generating revenue out of those songs. So how actually the copyright needs to be taken care, that whether, like, because nobody known who is the real copyright owner of that particular music, because it's a common in particular. So whether we can consider it as a copy left, or like how to take a call over such kind of work.
No, most in the music world now, everybody takes licenses. For remixing, for there is also what is known as a mechanical license. Which is known as the syncing license. So you would have seen that you create a reel on Instagram, and there is ready soft song available to, like sync with your video, whatever is there. The song and the video have no connection, but it is used as background music. So Facebook has signed a huge licensing deal with music labels for this mechanical syncing license. So people pay, like licensing, like revenue, royalties for whatever use they want to make of it. And music licensing, or cultural product licensing is such that you want to use a cartoon in particular presentation, there are sites which will license that cartoon to you. You go to, I think it is cartoonbank.com, which is all the New Yorker cartoons are there available for license. And you have to specify use, whether you want to use it in a magazine, you want to use it in a presentation, and you have to specify how many numbers, roughly, number of peoples you are targeting, what's your audience, and you have to pay accordingly. So
Does that answer
all
your
these-
question, Pankaj?
Yeah. Thank you.
Yeah, when,
And sir, I
because
have one more question,
otherwise you are looking at litigation, I mean, which nobody wants to get in these days, I mean, as such. And it all started with this Milli Vanilli thing, I mean, but now I think the music world is pretty organized, that even you want, like ready-made voices, you want ready-made jingles. There are sites from where you can download what is known as royalty-free music and background music, and they are known as loops, I mean, and all that, which you could use in your software without, like any royalties, because they work on a subscription model that you monthly pay this much, and then you can download as much of royalty-free pictures, musics, whatever you want.
Okay, Pankaj, I think you had one more short question.
Yeah. So, sir, you talked about one situation where you dealt with, for a client who has developed a machine learning software, and you were supposed to analyze, the risk attached to it. So the question was how much things were based out of open software and how much is closed software. So, but since if it is formed on open software, the modification will also go into open software, right? So, is there any discrimination in between, that you're working on the basis of your software is on open software, but you are converting into as a closed software thing?
So
So,
that needs
how
to
you're
be seen,
differentiating both these aspects?
Yeah, so that needs to be seen, because the very hard GNU license, GPL license, is not used by many players. I mean, now in the open source world. So lots of software is, released under very permissive licenses like MIT licenses. And that's what we found out when we actually looked at the code and what open source components they were calling or using. And a lot of it was from permissive, licenses. Code was released under permissive licenses. So it wasn't as much of a problem until you carried those copyrighted notices in the ultimate product also, I mean.
So, Hasit, just wanted to, for others in this audience, just wanted to check up if you have any comments. During COVID, there was this open COVID pledge and open license around it. I put a link there. Basically, many of these players volunteered to not do any lawsuits during the course of the pandemic, right? So even Moderna was one of them. At least for the course of the pandemic, right?
Correct.
And also there was also previously, before that, Tesla announcing open source.
Yeah, they had open source their battery patents.
Yeah, did you?
It wasn't open source. It was like an open license, because there was no source. I mean, they were just giving away their patents. I mean, license. They were patent licenses.
Yes, they were patent licenses, but I suppose it only says that they will not sue them, right? Was there an obligation to also ensure that the people who use it also put out inventions?
That's the big difference between copyright licenses and the patent licenses. In patent licenses, there is not much of this open source kind of licensing. Haven't seen any patent licensing which is like open source, where that if you make modifications, you'll also have to release them to public, I mean, as such. So there it's only that you can use, it for whatever purpose you want, and we won't sue you. That was like foreboding or essentially giving a pledge that we won't have we won't file lawsuits against you. So there wasn't any requirement that whatever you make modifications to this, you'll have to release to the public. I mean, as far as I remember the Tesla pledge, I mean.
Yeah. So I can understand that as a model for COVID, because there was a social problem there. What is Tesla's motivation for doing this?
No, their stated motivation was that they want to, further renewable energy. I mean, and that's their mission. I mean, to make renewable energy extremely common and all that. And others, I think, the battery chemistry was no longer a secret. If you look at, I think they are called Tesla's 4860 cells. I mean, they are like those Winchester bullets, I mean, which are put into a large, like an array of cells. The battery chemistry, people have reverse engineered it and found out that it's nothing like very special. The way they integrate all those cells and, use software to control how the aging of battery chemicals is managed, that's where their secret sauce lies in software, which they have not open source naturally. Neither they have open source their autopilot.
Yeah. So in effect, they're using that to essentially strengthen the ecosystem for their own business to flourish.
Yes,
right?
yes. And then also, what happens is that if, let's say, taking that battery chemistry as the starting point, if people improve, Tesla will seek licenses, right? Or buy those companies. So they want to push the field ahead that this is what we know. Can you make it better? Because if you can make it better, we'll buy you out or license it from you.
And there is a sort of a good faith kind of clause in it.
Yes. That you won't misuse it, I mean, to sue Tesla with, like that, I mean.
Okay.
There's something of that sort. I mean, they have a good faith use for it, I mean.
Yeah. And in Moderna's case...
before we move, let me just remind the participants, the feedback link is there in the chat box. So please do fill up the feedback form. Yeah.
Yes.
Yeah. And please give nice feedback. Otherwise, Venture Center won't invite me again. Sorry, I'm joking. Sorry.
Yeah, Hasit, anyway, that feedback is anyway useful because we do keep improving our content.
I'm joking.
Yeah, but there's also a question on what is the financial models on which these things work. For example, Red Hat's, Linux. What is the financial model around that, and why is IBM say interested in Red Hat, in buying Red Hat? And in other models also, how does the financial model work? How do they sustain themselves?
That's a good question. I mean, the financial models around free software, and a lot of people, there's academic literature, people from economic side who have, studied, what are the economic impacts of such, seemingly altruistic, models of software. One, what happened is that because Linux getting so popular, massive standardization happened in the server world. From IBM's mainframe, Z series mainframes to, they had a proprietary middle level computer, server, a mid-range server called AS400, which used to run their proprietary software called OS 300. Not surprisingly creatively named. All of that disappeared. IBM has, said, we'll just use Linux over it. So the unintended benefit for everybody in the ecosystem was that standardization happened and code could be run from one servers to another. Now you could argue that, this led to commoditization of server hardware, and that led to sinking of Sun. Sun had its own Unix version called Solaris, which was supposed to be much superior. And when Oracle bought it and, they open source Sun, which had some very unique tools,
Sorry, I think we lost you there.
Okay, no. So I think I was muted by mistake.
Okay.
So the economic models around it is that it led to a lot of standardization, a lot of hardware on which, Linux could run expanded. And a lot of applications from which you could make money now ran on many more, software platforms. So something like database, you want it to run from the smallest, mobile phone kind of computer to the largest mainframe. Maybe different flavors of it, but it's possible if, the underlying software is the same, which is Linux. So they achieved a lot of it, the network effects worked in such a way that a lot of people made a lot of money. So now coming to specific examples of why IBM was interested in Red Hat and bought it actually was essentially that a lot of customers of server software were buying a lot of cloud products. So Red Hat also has a cloud product, Red Hat Cloud. So now that cloud, if you see, is a software as a service model. So that software for that cloud may be open source, or like your Linux which accesses that particular files on the cloud may be all open source, but cloud as a service was paid.
Yeah.
So they were interested in that piece of it, and the IBM's cloud wasn't doing as well as say Google or AWS, or Google Cloud or AWS, or even Microsoft Azure. So they essentially bought it for that piece, and it's all right. In fact, there is a criticism that whatever we consider as open source is actually like it's Apple, Oracle, and IBM who fund the salaries of who are lead developers. So they have hired lead developers on almost all of the major software, open source software, and they are paying their salaries to essentially keep it updated. So
okay.
So that's
interesting.
Okay. In fact, Linus also took up a job for a short time, I mean, with some company, and there was criticism, but he left. I mean, that's what I hear.
Yeah. So there's a question on, are there any instances of any open source license being breached and any litigation?
Yes, there is a smattering of cases whereby this was breached, and open source.
And who sues in such cases?
No, it's been at a very early stage. People have either withdrawn or settled things. Nothing's gone till Supreme Court level in any country. This thing, and that's what is also claimed as the success of these open licenses, that they are so dangerous to touch. I mean, particularly the GPL, that nobody wants to mess around with it.
Yeah.
But there have been litigation. If you are interested in licenses, there have been litigation between Oracle and Google, and that is due to the Java interfaces. So Google essentially wanted a development environment when they launched Android, and they essentially picked up all the Java's, like function calls, and Oracle sued them, although Java is open source. I mean, the open source Java, Sun had open source Java long ago, much before they open sourced their operating system Solaris. So, but when Apple bought Sun and they saw that, Google is, it's very interesting. They have not copied any code. They have just the interfaces are copied. So in Android, you can make function calls, which are very similar to Java language function call, but ultimately the code to implement that function is written by Google. It's just the interface.
Okay. Fine. Final question before.
And Oracle lost. I mean
one final question. I know we are out of time, but just I can't resist it.
Sure.
So the government, especially DRDO, announced, this thing saying that they're going to basically grant free access to all their patents and so on and so forth. And then there was a push, saying, oh, everybody needs to do it open source. What is your view on it?
I think it's a good idea to, for stuff that is patents and all that, unless it is used, I mean, there is very little, benefit in it. I think if you are 15 years from the date of filing into the life of a patent and you see no use for it, anyway, in 5 years, it's going to be, in public domain. So might as well,
But why isn't it just better to just say allow it to lapse?
They should have, I mean, but lot of lot of organizations, a lot of people with patent owners think that, their patents are very valuable. But problem is, to apply them, make it into commercial products and all that. I mean, you would know better than anybody that how difficult that process is, or that journey is. So it's just that people either want to think that, oh, I can make money out of it and hence want to hold on to it. Or people think that, well, I maybe, I'll make something from it and I don't want anybody to copy. So patent world is very different from copyright world in that sense. It's very clingy to, because to get patent is very hard. It goes through a lot of filtration and examination, while copyright is generated on the fly.
Yeah.
So because of economics of creations are very different. I think the regimes which control them or have developed around them have been very different. Norms are different.
Okay, great. Thank you, Hasit. I really enjoyed talking to you today, and nice conversation as well as talk. I'll over to Mugdha and Sharvari to take it here.
Yeah, thank you, Hasit, for this wonderful session.
Sure.
And the time that you've given 2 consecutive sessions is quite a bit of commitment. So thank you so much for sparing the time.
Thank you, everybody. Thank you. Take care.
We
Bye
will
bye.
meet all of you on 30th of May for the next session, which is going to be around only collaboration agreements. And our speaker for that session is going to be Mr. Nihal Kothari. So we will meet after 3 weeks and again at the original timing of 4 o'clock. So please stay tuned for the next session. Thank you so much.
Thank you,
Thank
Hasit.
you.
Thanks a lot.
Bye.
Bye-bye.